Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today I have for you a measured and composed response to Legal Eagle, a very popular legal YouTuber who has put out a video about pardons, and specifically pardons in relation to President Donald Trump and pardons related to close associates or affiliates of President Donald Trump. Now, Legal Eagle would have you believe, and I encourage you to go watch this video. I encourage you to go watch his video as far as you can and take his perspective into account when you listen to what I have to say. All right. Legal Eagle has suggested that these pardons are unjust, undue, or somehow uncontemplated by the pardon power of the United States, and specifically the pardon power conferred upon the President of the United States by the United States Constitution. And I will humbly suggest that Devin is incorrect, that Legal Eagle is wrong. This isn't much of a surprise, but Legal Eagle is not correct in his assessment of the power of the pardon, of the justice of a particular pardon, or of the propriety of a particular pardon. He would lead you through 18 minutes of, first of all, Legal Eagle, stop crying. It's embarrassing. He would lead you through 18 minutes of crying about these pardons and try to get you to the conclusion that somehow these pardons are egregious offenses against the sanctity of the Union and beyond what was contemplated in the scope of the pardon power. I will present to you 3 short pieces of evidence as to why that's wrong. I will present to you the links to those pieces of evidence in full in the description, so you can go back and read them yourselves and take in the full scope of what is being said. And then I will let you make the decision as to whether or not Legal Eagle is correct, whether he is a reliable relator of information. He has a highly produced video. He looks great. Good job, Devin. You look fantastic. He's got a wonderful set of fake books behind him, and he uses infographics and scene transitions to make his video very, very respectable and approachable and relatable. And you can tell it has a massive amount of appeal. I think it's approaching or maybe has passed 600,000 views on YouTube right now, which is great. I congratulate him for doing that. But I'm still going to say it. You're wrong, bro. You're wrong, you're wrong, you're wrong. And here is why. So, for the first proposition that I'm going to affix to his rambling, because it is a rambling 18-minute mess, and apparently there's a longer uncut version available on Nebula, but like hell am I going to give this moron any of my money to figure out what it says. What I will do is go ahead and affix a couple assertions to him. And the first one I'm going to affix is the idea that this is somehow unprecedented or uncontemplated by the founders of this country. And I will point directly to Federalist 69. Federalist 69. This can be found through the arduous process of going to Google and typing in Federalist Papers Pardon. And you'll get 2 hits. One hit is Federalist 69. The other, I believe, is Federalist 74. And upon reviewing it, it's not really pertinent to this video, but I would encourage you to check out Federalist 74. It has an extensive review of the pardon power, but on a different issue. Federalist 69, in the 3rd section of it, states this, and I'll read it to you. We'll go through this. Thirdly, the power of the president in respect to pardons would extend to all cases except those of impeachment. The governor of New York may pardon in all cases, even in those of impeachment, except for treason and murder. Is not the power of the governor in this article on a calculation of political consequences greater than that of the president? All conspiracies and plots against the government, which have not been matured into actual treason, may be screened from punishment of every kind by the interposition of the prerogative of pardoning. If a governor of New York, therefore, should be at the head of any such conspiracy, until the design has been ripened into actual hostility, he could ensure his accomplices and adherents an entire impunity. A president of the Union, on the other hand, though he may even pardon treason, when prosecuted in the ordinary course of law, could shelter no offender in any degree from the effects of impeachment and conviction. Would not the prospect of a total indemnity for all the preliminary steps be a greater temptation to undertake and persevere in an enterprise against the public liberty than the mere prospect of an exemption from death and confiscation if the final execution of the design upon an actual appeal to arms should miscarry? Would this last expectation have any influence at all when the probability was computed that the person who was to afford that exemption might himself be involved in the consequences of the measure, and might be incapacitated by his agency in it from affording the desired impunity? The better to judge of this matter, it will be necessary to recollect that the proposed Constitution, the offense of treason, is limited to levying war upon the United States and adhering to their enemies, giving them aid and comfort, and that by the laws of New York is confined with similar bounds. Okay, so the idea here is that when the Constitution was being contemplated and written and proposed to the people and sent to the states for ratification, the Federalist here is arguing that the power of the existing governor of New York at the time is actually greater than the power of the president, because he can, even in cases of impeachment, grant pardons. So he can grant pardons all the way up to the predicate act of treason, which means he can create a scheme and participate in that scheme all the way up to the actual carrying out of that scheme. And the only thing that would stop him would be the scheme's failure and then a consequent treason charge. Now, what he's arguing here is that the president can only pardon insofar as impeachment is not involved. The moment anyone is impeached in this, the president's power to pardon is diminished or removed, including the president's own impeachment. And that own impeachment negates the consequences of the pardon by negating the power of the pardon. Therefore, the president's power is necessarily less than that of New York by including this, except in cases of impeachment provision. So this isn't the definitive tell-all aspects on the pardon power. However, it does show that the contemplated pardon power considers the very act of treason, and plots against the government, against the people, against the nation. All of it is considered within the pardon power, remembering that these men just participated in the greatest act of treason in the history of the world by creating the United States out of treason to England. They get to write the spoils of that. They get to create what happens. But the idea that they didn't contemplate political corruption, the idea that they didn't contemplate offenses against the Union in the pardon power, is to ignore their own history as creating an offense against England through the political and public aristocracy and elite classes. It wasn't the lower class of the English common folk that lived in the United States that created the revolution. Sure, they were participatory, but the people were men of means and of status, which gave it credibility and which brought the common people necessary under the fold of the fledgling United States that would become the United States of America. So this idea that this is some new thing or that it didn't contemplate these sort of actions is ridiculous, and it's embarrassing that Legal Eagle is glossing this or ignoring this entirely. I will next go to a case that Legal Eagle shows in his video, Ex Parte Garland, and this is a specific discussion of the power of a pardon over a man who participated in active hostilities against the United States. This was an attorney who lent his services, maybe even participated in the physical war, but the Civil War itself. Probably the second largest act of treason in United States history after the first one, which created the country, was the one that drove a wedge into it and created a rift, led to the loss of lives of hundreds of thousands of Americans, one of the greatest losses of life, if not the greatest loss of life we've ever sustained in a single conflict. And it was critically damaging to the fabric of the nation, and we are still reeling from the effects of it even today. If you check out people like Devin, who talk about it, who talk about the ongoing effects of racism and slavery and the histories of those things and how they impact our institutions even today. We're still dealing with the Civil War and Reconstruction. But that's getting ahead of ourselves. This is the Ex Parte Garland. This was decided by the Supreme Court of the United States in 1866, and I'm only going to focus on 3 paragraphs from the syllabus, which are then flushed out in the main decision below. And I encourage you to go read those that main decision if you want a full picture of it. It's approximately 30 pages. You can go check it out. I will have a link in the description below to go look at all of the discussion of the pardon power. It's mentioned quite a few times in this decision. But importantly, number 9, the power of pardon conferred by the Constitution upon the president is unlimited except in cases of impeachment. It extends to every offense known to law, and may be exercised at any time after its commission, either before legal proceedings are taken or during their pendency or after conviction and judgment. The power is not subject to legislative control. Just isn't. Number 10, a pardon reaches the punishment prescribed for an offense and the guilt of the offender. If granted before conviction, it prevents any of the penalties and disabilities consequent upon conviction from attaching. If granted after conviction, it removes the penalties and disabilities and restores to him all his civil rights. It gives him a new credit and capacity. And this is the only thing that Legal Eagle brings you from this case, which again is embarrassing in the scope that he is so unthorough in this whining diatribe that carries on. There is only this limitation to its operation. It does not restore offices forfeited or property or interest vested in others in consequence of the conviction and judgment. So, it can't restore things that are lost. However, it can prevent anything from being lost if it's done prior to the conviction. So number 11, the petitioner in this case, having received a full pardon for all offenses committed by his participation, direct or implied, in the rebellion, is relieved from all penalties and disabilities attached to the offense of treason committed by such participation. For that offense, he is beyond the reach of punishment of any kind. He cannot, therefore, be excluded by reason of that offense from continuing in the enjoyment of a previously acquired right to appear as an attorney and counselor in the federal courts. So this is about restoring his status at bar. But any and all punishments for any and all offenses, including in outright rebellion against the United States. Finally, I'll bring to you Ex Parte Grossman. This Ex Parte Grossman is an interesting case from 1925, and in it, the court goes through a very thorough and extensive read of what the pardon power meant at the time of drafting. And it's interesting to hear discussions about like originalism versus progressivism on the Supreme Court, because if you go back to earlier cases, you will find that originalism is the only ism. It's not like a new construction. Originalism, the Supreme Court is constantly searching for what the founding fathers meant. But I will also link to this specific case down in the description below, and you'll be able to look at it for yourself. But we're just going to read page 112 here. With this authoritative background of the common law and English history before the American Revolution to show that criminal contents were within the understood scope of the pardoning power of the executive, we come now to the history of the clause in the Constitutional Convention of 1787. The proceedings of the convention from June 19, 1787 to July 23rd were by resolution referred to a committee on detail for report of the Constitution. 2 Farron's Records of Constitutional Convention, page 128 and 129, and contained the following on page 146. The power of pardoning vested in the executive, which his pardon shall not, however, be pleadable to an impeachment. On August 6, Mr. Rutledge of the Committee on Detail reported the provision as follows. He shall have power to grant reprieves and pardons, but his pardon shall not be pleadable in bar of impeachment. This is exactly what the king's pardon was at common law, with the same limitation. On August 25th, the words except in cases of impeachment were added after pardons, and the succeeding words were stricken out. On Saturday, September 8th, a committee of 5 to revise the style and arrange the articles was agreed to by the House. As referred to the Committee on Style, the clause read, he shall have the power to grant reprieves and pardons except in cases of impeachment. The Committee on Style reported this clause as it now is, and he shall have power to grant reprieves and pardons for offenses against the United States except in cases of impeachment. There seems to have been no discussion over the substance of the clause, except that a motion to accept cases of treason was referred to the Committee on Style September 10th, was not approved by the committee, and after discussion was defeated in the convention September 15th. Okay, so this is the idea here. The founders contemplated the idea of treason, of rebellion, of sedition, of corruption. They contemplated all of these things, and what they conferred upon the president in his power was that power to pardon was the same power to pardon as that of the King of England at the time, which meant a total pardon of any and all offenses. And if it sounds like tyranny, well, I guess that's because it comes from the power of a king and is only limited by the power of impeachment. That's it, Legal Eagle. Stop misleading people into thinking this is somehow improper, uncontemplated, untoward, unreasonable. This is well within the scope of the pardon power. You know this. And the fact that you're lying about it is disingenuous, dishonest, and gross. Also, you're terrible. You're terrible. All right, guys, check out the stuff below. Leave a comment. Tell me what you think. Go check out the links in the description, and have a good one. Happy New Year. Peace. Peace.